That is case number 108570, State of Kansas v. Luis A. Aguirre.
May it please the court, Deborah Wilson appears on behalf of the defendant appellant Luis Aguirre. Chief Justice Nuss, I'd like to request 3 minutes rebuttal this morning.
3 minutes is granted.
Thank you. Luis Aguirre was convicted of capital murder. He's currently serving life without parole. The main issue in this case involves the admission of custodial statements that Luis made after telling his interrogators that he was taking his rights. He challenges the admission of these statements on 2 grounds. First, on the grounds that they were obtained in violation of his rights under the Miranda decision, and second, on the grounds that the statements were also involuntary. And both those issues depend on this court's view of Luis's statement to his interrogators. This is where I guess I'm going to take my rights. I want to turn David into his family and I'll be back here. I mean, I would like to keep helping you guys. I just want to. And at that point, his interrogators cut him off. They kept him from completing his sentence by talking over him, and they told him, you are not going to be able to leave. We have search warrants. We're executing those warrants, and they continued to question him. If you haven't looked at the DVD of the interrogation, I would urge you to look at that portion. It's time-stamped 14:57:35, so I assume that means it was at 2:57 in the afternoon. Was this an ambiguous request or an ambiguous invocation of his right to cut off questioning? We contend that in the entire context of the exchange between Luis and his interrogators, it certainly was. And the case law tells us to look at the entire context of a suspect's statement to determine if he or she is actually invoking his rights. What we have in this case is that the questioning became accusatory. Luis says for the first time that he wants to leave. That request is ignored. The questioning continues. Then he says, this is where I guess I'm going to take my rights. He repeats that he wants to leave, and when he tries to say what else it is he wants to do, he's cut off, and the questioning continues unabated.
Here's the problem I'm having with your argument, so see where you can set me straight. I mean, I've read the entire transcript of this particular interview and have the DVD, and it's pretty clear that what he says is, I want to take my rights because I want to get my kid taken care of here, but I'll be back.
Right.
Because I want to help you. And then the detectives then come in and explain that they've got search warrants going on and that things have gone on long enough in this discussion that he's probably not going to get to go home. And that's because of what had happened before. And it's admitted. And then he shakes his head. I mean, they say, you want to keep helping us? He shakes his head. He does all that. And then they have a long discussion where there's a dialogue. And you can't describe it as anything other than a free and voluntary dialogue. And he never holds his hand up again and says, I want a lawyer. I want to stop answering questions. None of those things that we usually throw a flag down on. So when you take the whole, and then at the end of this discussion, he's writing out a voluntary list of things, both names and addresses and things. So, I mean, again, you've got that one phrase, but isn't that really all you've got? Is just that one phrase?
We have that one phrase combined with 2 requests that he be allowed to leave. And I'd like to address something that maybe you're suggesting by your question, that maybe a suspect has to invoke his rights twice. Because what we have here is he references his rights and it's completely ignored. And I think he was actually trying to clarify that again when he was talked over by the police officers. And this idea of, I will come back and talk to you later, what that clearly means to me is, I'm ready to stop talking now because I want to talk later. And I would compare that with the New Mexico case, State versus King, that I cited to the court in my brief. In that case, remember, the defendant said something to the effect of, I'm rather intoxicated, don't want to talk now. I'll talk later. And the New Mexico Supreme Court had no problem saying, oh yeah, that was a clear invocation of his rights. So my answer is, my contention is he invoked his rights once, he was ignored, he's not required by Miranda to continue trying to evoke his rights, especially when he tries to keep talking, he's interrupted and talked over. And in fact, I contend that despite what the police officers said during the suppression hearing of, oh, we didn't know what he meant when he referenced his rights, I would suggest to you that the action of the police officers in cutting him off suggests they knew exactly what he was doing, and they didn't want him to say it again. Because if he said it again, he might have, in the words of Davis versus United States, said it with the discrimination of an Oxford Don. I would like to now invoke my constitutional right to end this interrogation as you advised me when you gave me my Miranda warnings. I think they wanted to make sure that he didn't do that in this case. And remember, Davis also tells us you don't have to invoke your rights with the discrimination of an Oxford Don. And I think that's clearly what he was doing. We contend that an ignored request that he be allowed to leave, followed by a reference to his rights, followed by another request that he be allowed to leave, equals in this context an unambiguous invocation of his right to end the questioning. The trial court disagreed. The trial court found that the words, I guess, rendered the statement ambiguous. And I think, Justice Biles, you're saying that maybe the I want to keep helping you guys rendered the statement unambiguous, but that's not what the trial court focused on. It was this I guess part. That's a very interesting finding in light of the fact that neither interrogator said, oh, we were confused by the I guess. We didn't know if he really meant he was taking his rights at that time. Instead, Detective Runyon and Detective Lewis testified that they both thought he meant he wanted to leave. And they both focused on the fact that they thought he was trying to take his fiance's sons home. And they said, oh, we didn't think he wanted to end the interrogation. He just wanted to take his fiance's son home. But of course, taking his son home would have ended the interrogation. Yes, Justice Johnson.
Was he entitled to do that?
No. And he was never told.
Let me clarify what
Okay.
you're saying no to.
Right.
Was he entitled to stop the interrogation, take the child someplace, and return? He could not do that?
I would say not under Miranda. Not under Miranda. Miranda doesn't tell you.
He was told, if you decide to answer questions now without a lawyer present, you will have the right to stop answering at any time, end quote. So why couldn't he have stopped at that time and then returned without any ambiguity? I mean, if he wanted to do that, was that permissible?
Well, Miranda doesn't say you have the right to leave. Miranda does say you have the right to stop questioning, and you've just taught me a valuable lesson about leaping to conclusions about what your question is. When he was not advised that he had the right to leave. So when he said, I want to take my rights, clearly he was referring to the right to end the interrogation. Now, leaving would have accomplished that, but they weren't going to let him leave. They weren't going to let him leave at that part. In fact, what he had been told, the exact words of the Miranda warning he received were, as you referenced, Justice Johnson, if you decide to answer questions now without a lawyer present, you will have the right to stop answering at any time. So when we say, well, what rights was he invoking? We think clearly that I want to leave, it's ignored, I'm taking my rights, I want to leave. In combination, that means he wanted to end the interrogation.
Why does it mean that and not just I want to take a break to take care of the kid? To make sure that the kid is taken care of. Because during this interview, over 3.5, 4 hours, they took a lot of breaks. Mm-hmm. They took breaks before this, they took breaks after this. I mean, they went to the bathroom, they got water, asked him if he wanted sodas and that sort of thing, and they did. And they'd take breaks, and then they'd come back, and he'd start right back up talking about whatever the story was at that particular moment. I think when he says, I take my rights and because I want to deal with David, I don't know that clearly communicates. I mean, this is the problem I'm having, so I want you to fight with me on it, I guess. But I don't know how that communicates, I want to stop the questioning and be done with you guys, as opposed to what he says, which is, I want to take care of the kid, and I want to come back and keep talking.
I'm fine with your interpretation because I think that supports my position too, because what would a break have done? It would have ended the questioning for then. I think maybe what the police officers didn't understand about this when they were going, oh, he just wanted to take his son home. I think they didn't understand that you don't have to say, I want to stop answering questions and I will never answer another question to invoke your right to end the interrogation. What you have to say is, I want to stop now. And I think that that's clearly what he was saying by that, because a break would have ended the questioning. And he wanted to stop the questioning. And in the context of this, it's like the defendant in King. The defendant in King said, I'll talk to you later, but I'm not going to talk now because I'm intoxicated. And the New Mexico court said, you know what? You don't have to explain why you want to stop. Miranda doesn't require a good excuse for stopping. Miranda only requires that you say, I want to stop the interrogation. And we're saying that right wasn't scrupulously honored, as Mosley requires for the resumption of questioning after an invocation of rights.
Before you run out of time, can you jump to the second interview and as
Yes.
to how this taints that? Because,
Yes.
of course, by 3 days later, he's been arrested for double murder, and they show up, and he still talks to him. Signs his waiver, he has it read, reads it back, and all that. So what is it that taints from the first to the second?
Okay. Before giving my position on this, I want to point out that I think the state and I disagree about what your template is for analyzing the second interview under the Miranda violation. We agree that Swanigan is the case you use for the voluntariness, but it's our contention that for the second interrogation, when you're analyzing it under the Miranda question, the case you look to is the United States Supreme Court case of Michigan versus Mosley, because Michigan versus Mosley addresses the situation where a suspect has invoked his right to end the questioning, and then the question is, can the police ever reapproach that suspect with new questions, which is exactly what happened in this case. And under Michigan versus Mosley, the first and primary question that the court has to ask is, was the invocation of rights scrupulously honored? And of course, in this case, it's our contention that if you find I'm taking my rights is an invocation of his rights, then clearly it wasn't scrupulously honored. It wasn't honored at all because the questioning continued. So in Michigan versus Mosley, the first question is, was the right to stop the interrogation scrupulously honored? In this case, we say it was not. But if it was, then the court also looks to, were there fresh Miranda warnings? Was the subject of the interrogation a different subject? We contend you don't have to get to those other things, because if you find this actually was an invocation of his rights, then it wasn't honored at all. And what Luis learned, and here's why it taints the second interrogation. Luis learned this. I've been told I have these certain constitutional rights. And I decided that I want to either end the questioning or take a break, if you want to look at it that way, Justice Biles. Either way, I want to stop this now. And they ignored me when I said I wanted to leave. So then I thought back and said, well, I was told I had these rights. I was told I had the right to stop the questioning. So, okay, I'm going to take my rights now. I want to leave. No, we're going to continue to ask you questions. So Luis learned that despite the form he read, despite the form he signed, telling him that he had these rights, that in that room with those interrogators, he had no rights. They were going to continue to question him no matter what he said, and when he tried to say it again, they would just talk over him. So we say no number of new Miranda warnings can remove the taint of what he learned in that first interrogation, which is, here with us, you don't have those rights to stop the questioning. And that's why we believe the second interrogation should be suppressed as well. I see that I'm out of time.
Any more questions? Thank you, counsel.
Thank you.
May it please the court, the state appears by Assistant Solicitor General Natalie Chalmers. At the time he invoked his right, it's unclear what the right was that he was invoking. He was not free to leave. The cops turn around and tell him basically he's not free to leave because of the search warrant. It appears he wanted to invoke his right to leave. And right to leave is not the same thing as the right to remain silent.
Would the leaving have stopped the questioning?
Apparently temporarily. He wanted a break. We don't, when we give them a bathroom break.
Does it matter? Your opposing counsel said it doesn't matter whether he wanted a break or to walk out the door.
I think it does matter in this case. The condition he wanted was to make sure that David was taken care of.
Let me back you up then. So what case are you pointing us to that indicates the reason for wanting to stop the questioning matters?
It's a totality of the circumstances. You're supposed to look at the totality of the circumstances to determine whether or not there was an ambiguous or an equivocal right. Here, or an unequivocal. There was no unequivocal assertion. He said, I guess I'm going to take my rights here. He talks about just wanting to take David back and then doesn't proceed to say anything to the cops until he knows David is taken care of.
Let's put the guess in context. What he said is, quote, this is, I guess where I'm going to take my rights. What he was guessing at was the timing of the taking the rights, not the whether he would take the rights. That's how I read that. I guess this is where I do this. Isn't that what he said?
I still think the phrase, I guess, isn't unequivocal. I don't know that I see a distinguishment between, I guess this is where I'm going to take my rights as being right now versus I don't really know if I'm going to take my rights. No matter what, when you say I guess, I think that's equivocal. And the cops then did exactly what they were supposed to do. They asked clarifying questions. They told him he couldn't leave because he couldn't at that time due to the search warrants. And then they asked, do you want to keep talking to us? They repeatedly asked that. And he said yes. And then he proceeded to keep talking to them. They clarified here that yes, he did want to keep talking to them, and no, he was not invoking his right to remain silent.
Now, you would agree that when he was read his rights, none of them referred to his right to leave.
Right.
And so when he says, I invoke my rights, he wasn't referring to a right to leave by reference.
Well, they hadn't told him at that point that he wasn't free to leave. He came in voluntarily.
Well, what I'm getting at is when he said, I invoke my rights, and the police says, well, we thought he just wanted to leave. His rights didn't include a right to leave. So how do you make that leap?
Just because...
My question is, why could they infer that he was referring to the right to leave when they hadn't told him he had a right to leave?
Well, I think he could easily interpret the stop answering as a right to leave as well. I don't think that just because he wasn't specifically told he had a right to leave doesn't necessarily mean he didn't think he had the right to leave. Here, apparently, he thought he had the right to leave because he wanted to leave. And it turns out at that time he didn't have that right because he was in custody at that point and they weren't going to let him leave. But even if you find that there was an unequivocal invocation of a right here, I think the second confession still comes in. And if the second confession comes in, it's harmless. I disagree that the scrupulously honored is the sole test. If that's true, no police officer could ever talk to Mr. Aguirre again. If this was an invocation of a right and it wasn't scrupulously honored, cops would be per se banned. I don't think that's the test. I think the test is basically the same taint test we've used. This court has used repeatedly. I think here there was a 4-day break in time. Well, I know here there was a 4-day break in time. The officers learned new information. They learned that the victim was still alive on the day that Mr. Aguirre said she was dead. I'm sorry.
That isn't correct. The police could talk to him again if he had a lawyer appointed.
I don't know, because this was the invocation of the right to remain silent, scrupulously honored. This isn't a Sixth Amendment right to counsel.
But that's the whole
Or Fifth
point, is
Amendment.
once counsel's appointed, then he can counsel, he or she could advise his or her client about what the action is taken next. The law enforcement then approaches counsel to talk. Doesn't ban further interviews. It just has to be with the representation of counsel, which happens all the time.
That's true, but that's not the test that they're advocating. The test they're advocating was it scrupulously honored? If it wasn't scrupulously honored, we can't talk to them. They're not saying that if there's counsel, suddenly that waives any kind of the fact that the Fifth Amendment right to talk was violated. They're not looking at a totality of the circumstances test in order to figure out if there was taint, which is what the state would encourage you to do in this situation.
So you're saying the test is whether the second interview was tainted by the first?
Yes, I'm going for a
And
taint
if someone
test.
confesses, why isn't that a taint?
There wasn't really a confession here. He didn't say, yes, I intentionally killed these people. He said, I accidentally killed these people, and in the process of doing so, lied numerous times about numerous things. In the second interview, they come in with different interrogators. One's the same, one is different. It's 4 days later. They have new information because they know that she was alive when he last claimed she was dead. They know that she left with him from the mission, or at least there is strong evidence to support that she thought he was leaving with him. They found a car that looked like him. They have new information at that point. I think that gets rid of any taint. And then he then says he says a new story, I think, or the same story of the accidental death.
What happens at the end of the first interview? He remains in custody, doesn't he?
Yes.
And is he appointed counsel at that point, or do you know?
I don't believe the record says that, and I
So
would
he
guess not.
never appeared at a first appearance, or under what conditions was he confined?
I am not clear from the record on that point. And
So
they-
for 4 days he's in custody. There's some ambiguity whether he invokes his rights, but he's not appointed counsel in the meantime during those 4 days, as far as you know.
as far as I know, no.
Okay.
Just reassert my position that, and I don't know if this court has any questions on the voluntariness or the prosecutor.
I have a question on harmlessness.
Okay.
What if obviously your position is if the second interview is allowed, then it's harmless error. What about if it's
Entirely?
if neither interview is allowed?
If neither interview is allowed,
What evidence is there?
yes, the evidence
This
that we
question.
have, the state still has, is she dies in Ogden, Kansas, and has no connection to Ogden, Kansas. She is from Chicago, has never been to Ogden, Kansas. The grave site was still dug up 3 days. She leaves the mission with him, disappears in Ogden, Kansas, is found dead in a grave site that was open for 3 days. She and her son.
Why is the open gravesite for 3 days this point to him?
I don't know that it points to him, but it points to premeditation. And also, he is near Ogden, Kansas. He's the only real reason she would ever be there. He has said in emails, I left all this out, that he wanted her dead. He knows that he is on a timeline that she is going to go after child support if he doesn't do something about it. I think this is all strong evidence of his guilt, and on a retrial, we could definitely get another conviction. I'm not sure it meets the constitutional harmless error standard.
I'm sorry, I'm still a little confused about what Justice Lugar just asked about. The open grave points to premeditation. Can you just explain that to me?
Well, generally you don't dig a grave and then not kill people and put it in. So he dug the grave 3 days before he put their bodies in there.
Okay, now I understand what you meant. Okay, thank you.
Yeah, that would be my premeditation argument. If there are no further questions, the state would just respectfully, I'm sorry?
I do have a question on the lesser included offenses. Well, actually, it's the prosecutorial misconduct issue. where the prosecutor said you only go start working your way down the lesser included crimes if you find the defendant not guilty of capital murder. Would you agree that that's really not an accurate statement? Because they don't find him not guilty. It's if they cannot agree.
If they cannot agree, he's guilty.
Which to me is a little different than finding him not guilty.
I don't know that the jury would necessarily look at it through our lens of legality and say that a finding of not guilty has to be unanimous, which is, I know, the argument that Aguirre is making in this case. I think it could be more artfully phrased, but I don't think that it's a misstatement of law. If they find him not guilty, they move on.
Well, it's not whether they do find him,
Right,
it's whether
whether they
they are
vote.
required to find him not guilty before they even look. That's what the prosecutor was saying. You don't even look at those lessers. You focus on capital and you have to find him not guilty, and if you do find him not guilty, then you can start looking and see what these other lessers are.
See, and I read the prosecutor's statement as saying if we meet our burden of proof, we have the burden of proof, he says that, beyond a reasonable doubt. If we meet our burden of proof and prove beyond a reasonable doubt that he is guilty of capital murder, then you don't get to the lessers. That's what he was trying to say. I don't think he was trying to nullify his proof. I don't think he was trying to say that you have to unanimously agree that it's not guilty before you move on. Even if he did misstate it, or it could have been more artfully stated, I can't see how it's anything but harmless here. The jury was correctly instructed on the lessers. The jury was told that the law to be followed was the law given in the instructions. The prosecutor himself even said that during closing. The jury was read 3 pages of lessers in the transcript prior to their deliberations. I think they well knew that there were lessers they could get to if they could not unanimously agree on capital murder. And I think they unanimously agreed on capital murder, as found by the fact that they all unanimously said that was their verdict after they were polled.
I want to pull you back over to the 2 interviews.
Okay.
And let's hypothetically assume that we don't like the first interview and we find the first interview taints the second interview, so you're done with that. Did you make a harmless error argument if those 2 things happen?
My only harmless error argument was based on the second
Right.
confession being used. And then I sort of attempted to make one today, but I think you could find, if the burden was not on me, if it was the old burden, where the burden was on the defendant to show error beyond the constitutional reasonable doubt standard, I might be okay. But here, I don't know that I can do it where you would say that the confession didn't affect the verdict at all.
Tell me
Statements.
what the emails said again and what evidence came in about it.
The emails said
These
were
were emails
bickering
between him and her,
Yes,
right?
emails between him and
Yeah,
her, and they
okay.
were bickering back and forth. And she says, basically, you have until September 20th to help in some way, shape, or form, because she's living in a rescue mission at the time. Or I'm going to go after you for child support. And on that deadline, he picks her up. He also says, she talks about wanting him dead, and he talks about wanting her dead as well.
That was in the text of the emails.
Yes.
I understood the other stuff was.
I think I specifically, hopefully anyway, quoted that email.
Okay.
Oh, I just have, he also previously admitted to hating her and wanting to kill her in emails sent months before her death.
And don't we also dig up an email that came after she's dead? Where
Yes.
he's sending it to her
That's right,
saying, where
after-
are you?
Yeah, after she is dead, at least according to his version of the timeline of death, he sends emails basically trying to figure out why she's not responding to him all of a sudden.
And those emails come up as a result of the search warrants that are completed in the period of time between the first and the second interview. Is that right?
Yes, I don't think there's any argument that any of the other search warrants or anything are off the table because of the confessions. None of that is.
Yeah, I'm not suggesting
Right.
that. I'm just saying when they pop up between the first and the
Yes,
second.
they don't have them during the first interview. There was no way they'd get the electronics that fast.
Any more questions? Any further presentation?
If there are no further questions, the state would just respectfully request that you affirm the conviction in this case. Thank you.
Thank you, counsel. You reserve 3 minutes for rebuttal.
Thank you, you, Your Honor. I will continue to disagree with Ms. Chalmers about whether we apply Mosley or Swanigan to that second interview when we're discussing the Miranda violation. But under Swanigan as well, I think the second interview is irretrievably tainted by the constitutional violations in the first. The factors that we look at under Swanigan are passage of time, intervening circumstances, and purpose and flagrancy of the prior conduct. I think that the flagrancy in ignoring his invocation of his rights hopelessly taints that second interview. On the issue of as we framed it, prosecutorial misconduct on the lessers, we think obviously this was a misstatement of the law. By telling the jury that they had to first acquit Luis of capital murder before considering the lessers, the jury learned that they had to be unanimous. They all had to agree that he was not guilty of capital murder before they considered lesser included offenses. In this case, because of the nature of capital murder that requires 2 premeditated intentional murders, and the facts in this case, where a jury reasonably could have found that Tanya's death was either not premeditated or unintentional, that they could have reasonably returned a lesser verdict on the charge against Tanya. But because the prosecutor says, well, you have to acquit him first, then one person holding out for a capital murder conviction would have prevented the jury from considering those lessers. So we think in this case, oftentimes there is kind of a misstatement of this aspect of the law, and I think this court has always found it to be harmless error. I think in this case we can't find it harmless because the jury really reasonably could have returned a lesser on Tanya, so then there wouldn't be a conviction for capital murder.
I had a question that I forgot to ask
Okay.
in the first round about prosecutorial misconduct. I read your briefs on reversibility to sort of concede no ill will.
Yes.
Maybe a misstatement of the law, but not gross and flagrant. So we sort of get down to then the burden on reversibility.
Mm-hmm.
Okay.
I really don't think the prosecutor was trying to trick the jury. I think it was just one of those things that comes out of your mouth. However, I think the effect is bad enough that it's reversible.
Just a clarification too, is that what I asked Ms. Chalmers, your client was detained for 4 days in Texas, and during that detention there was not a first appearance or any kind of opportunity, the court didn't intervene for counsel, anything like that. You were
Right.
just detained?
Yes.
I mean, you can just detain someone for 4 days for an investigation? Do you know?
I have no idea. In the interest of full disclosure, there was some discussion about an attorney, but it was of the nature of, are you going to get an attorney? And I think he did tell them, no, I'm not going to get an attorney. I think that happened at the very beginning of the second interrogation.
Okay.
Any more questions? Any further presentation? All right, thank you, counsel.
Thank you.
Thank you both for your arguments this morning. The court will take this matter under advisement.